Hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today let us learn the new topic Outer Space Treaty. Outer space is nothing but it is the area of the universe where the atmosphere of the earth ends. In other words, where the aerial sovereignty of the state ends, there the outer space begins. It also includes all the space about the lowest perigee achieved by any satellite put into orbit. Celestial bodies and the moon, these are all parts of the outer space. What is the law on outer space? The outer space acquires importance in the international law when USSR has first launched the Sputnik on October 4th, 1957. Since the number of manned and unmanned satellites, probes entered into outer space and celestial bodies have been launched by some other states as well. The acts of different states in the outer space led the United Nations to make some rules and regulations in this part of the universe. The laws which has been made to regulate the relations amongst the state and their relationship with the international organization in the sphere of the outer space bodies and the moon and other celestial bodies is nothing but space law. Outer Space Treaty 1967. On December 19, 1966, the General Assembly, through a resolution, adopted a text on the treaty on principles governing the activities of the states in the exploration and use of outer space, including the moon and other celestial bodies. The resolution was adopted unanimously. It is to be noted that most of the principles included in the declaration, which was adopted in 1963, were incorporated in this treaty of 1967. The treaty was opened for signature on January 27, 1967 and came into force on October 20, 1967. As of May 2017, 106 states are parties to this treaty. However, a treaty is binding not only to those states which are part of it, but all states in view of the fact that rules regarding the outer space has been cropped as a customary rule of international law. Freedom of exploration of outer space. Article 1 of the treaty provided that outer space, including the moon and other celestial bodies, shall be free for exploration and use by all states without any discrimination of any kind on the basis of equality and in accordance with the international law, and it has free access to all areas of the celestial body. And Article 1 also gives a confirmation that it is for the benefit and interest of all the countries irrespective of their degree of economic or social development, and it is a province for all the mankind. So this is the freedom of exploration of outer space given to all the countries and all the states, whether they are part of United Nations or not. Non-appropriation of outer space. While outer space is free for exploration and use for all states, Article 2 provides that area cannot be appropriated by any state. No state can claim sovereignty over them by means of use or occupation by any other means. So there is no appropriation of outer space. Whether I have reached the first or last, it doesn't mean anything. No appropriation of outer space. Peaceful uses of outer space. Part 2 of Article 4 of the treaty provides that outer space, the moon and other celestial bodies shall be used by the states exclusively for peaceful purposes only. Thus, establishment of military bases, installations and fortifications, testing military maneuvers on celestial bodies, this is all not allowed. This outer space is only used for peaceful purposes. Jurisdiction of states over objects launched. How much is the jurisdiction of that state? The treaty under Article 8 lays down that a state or a party to the treaty on whose registry an object launched into the outer space is carried shall retain jurisdiction and control over them and over any personnel thereof while in outer space or on the celestial body. International responsibilities for national activities. The treaty established the states internationally responsible for all the national activities in the outer space carried out by both government and non-governmental agencies. When the activities are carried out in the outer space by an international organization, responsibility for compliance with this treaty shall be borne by the international organization and by the state which are parties to the treaty participating in such organization. So how is the responsibility or how prolonged is the international responsibility for the national activities done by such states? Assistance to personnel of spacecraft. Article 5 of the treaty provides that states which are parties to the treaty shall regard astronauts as an envoy of mankind in outer space. They shall render all possible assistance in the event of accident, distress, emergency landing on the territory of any another state. When astronauts make such a landing, they shall be safely and promptly returned to the state of registry of the space vehicle. Promotion of international cooperation in the use of outer space. So, Article 10 of the treaty provides that states which are parties to the treaty to consider on the basis of equality any request by other parties to the treaty to be afforded an opportunity to observe the flight of the space objects launched by other states.